Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Yesterday, as counsel for Stephanie Jones and counsel for Wayfarer wrote letters to the judge regarding Edgeworth Security documents, Justin Baldoni's attorney Mitchell Schuster wrote to the judge regarding the Vanzan lawsuit, laying out why they feel it was improper for them to obtain evidence that way. Edgeworth was the firm they used for security services when terminating Jennifer Abel. They had a security guard present, at least one, and then they had some of their technicians go through her phone and her laptop and take forensic evidence off those devices. Justin Baldoni and Wayfarer have tried to subpoena certain documents from Edgeworth, while Stephanie Jones has asked the judge to prohibit them from enforcing that subpoena. The crime-fraud exception strips the privilege from attorney-client communications that relate to client communications in furtherance of contemplated or ongoing criminal or fraudulent conduct. The exception also applies to the work product doctrine. For the crime-fraud exception to apply, there must be a probable cause that a crime or fraud has been attempted or committed, and that the communications were in furtherance thereof. Courts have applied the crime-fraud exception where a party's actions in discovery are found to be calculated and purposeful litigation misconduct. On August 21st, 2024, Jennifer Abel arrived at JonesWorks' office where she was ushered by Edgeworth Security personnel into a conference room, falsely imprisoned by Edgeworth Security personnel via its intimidation and implied pressure/coercion, and then coerced by JonesWorks' chief of staff and lawyer present in the room to hand over her JonesWorks-issued cellular phone to Edgeworth technology personnel, which she was told was solely to facilitate the release of her personal phone number. In truth, and without Miss Abel's knowledge or consent, Edgeworth's technology personnel forensically accessed everything from her personal iCloud and email accounts available on the phone, her text messages, emails, personal photos, and delivered the materials to its client, JonesWorks, which then had unrestricted access thereto. JonesWorks acknowledges that it possesses Miss Abel's private communications, includes such communications in its pleadings, and admits they were forensically extracted from the phone by JonesWorks' IT specialist. As detailed in Miss Abel's responsive pleadings, JonesWorks' misconduct, including through its agent Edgeworth, JonesWorks' misconduct, including through its agent Edgeworth, constitutes one, a violation of the Computer Fraud and Abuse Act, because JonesWorks intentionally accessed Miss Abel's cloud-based accounts hosted on remote servers by non-parties and obtained her private data without her consent. Two, a violation of the Stored Communications Act, because JonesWorks accessed, intercepted, collected, financially benefited from, and or disclosed Miss Abel's emails and text messages. Three, a violation of the Federal Wiretap Act, because JonesWorks intentionally intercepted, used, and or disclosed electronic communications within, to, and from Miss Abel's mobile device, email accounts, and iCloud, and because JonesWorks diverted those communications to Blake Lively, as specified below. A violation of California Penal Code Section 502C for similar reasons. 5, an invasion of Miss Abel's privacy, and 6, conversion. Is that all? Jesus. The same day, August 21st, that JonesWorks improperly obtained Miss Abel's private communications and data, and in the days that followed, JonesWorks disclosed the information to Blake Lively and or her agents. At the time, Lively was reeling from a storm of self-induced negative publicity surrounding It Ends With Us, and she saw an opportunity to use the ill-gotten communications to spin a false tale of a smear campaign to the New York Times by cherry-picking and splicing communications which, when viewed in full context, demonstrate an effort to prevent Lively's vicious behavior and malignant persona from overshadowing the film. However, because JonesWorks had illegally obtained Miss Abel's communications and then improperly disclosed them to Lively, Lively needed a veneer of legitimacy to explain her possession of the stolen materials prior to giving them to the Times. On September 27th, Lively and her counsel initiated a proceeding in New York State Court, Vanzan Incorporated versus Does 1 through 10. The sham action was a transparent ploy to manufacture a procedural vehicle by which Lively could subpoena JonesWorks for Miss Abel's communications without notifying any of the Wayfarer parties, including Miss Abel, all of whom lacked notice thereof and were deprived of any opportunity to object. The plaintiff, Vanzan Incorporated, is an inactive corporation affiliated with Lively and her husband, Ryan Reynolds, and unrelated to the film. The Vanzan complaint is devoid of specific allegations against anyone, much less Miss Abel, relies exclusively on recitations of boilerplate legal jargon, and implausibly alleges that Vanzan is unable to identify its own contractual counterparties. After the sham action was filed, Vanzan issued a subpoena to JonesWorks pursuant to CPLR 3120, which permits the service of a subpoena merely upon commencement of an action, unlike the federal rules of civil procedure. Vanzan, Lively, did not name any of the Wayfarer parties as defendants in the sham action because doing so would have required service of a copy of the sham subpoena upon them and enabled them to move to quash it. As planned by Lively and JonesWorks, JonesWorks did not object to the sham subpoena, as any reasonable recipient thereof would have done given the lack of any specificity or coherence in the complaint and the contractual obligations they would be violating, but instead blithely surrendered the entire contents of Miss Abel's stored communications a second time to Lively without Miss Abel's knowledge and to fabricate a protection of legal process. Tellingly, on December 19th, the sham action was discontinued. The next day, Lively filed a complaint with the California Civil Rights Department and included Miss Abel's communications therein. On December 21st, the Times published an article containing Lively's allegations and Miss Abel's private communications. Despite repeated demands, Lively's counsel has failed to provide the Wayfarer parties with the sham subpoena. In her amended complaint, Lively represents to this court that she obtained Miss Abel's communications through legal process, including a civil subpoena served on JonesWorks LLC. JonesWorks similarly represents that it received a subpoena for the phone's contents. Neither Lively nor JonesWorks told this court that the sham subpoena was issued in a case where Lively intentionally omitted herself as the plaintiff to avoid publicity, intentionally failed to name the Wayfarer parties as defendants or any actual defendants to avoid the obligation to notify them of the sham subpoena, and where Lively had no intention of actually litigating the claims in the sham action. Equally as bad, JonesWorks counsel publicly claimed that JonesWorks disclosed Miss Abel's communications to Lively in response to a court-ordered subpoena. It is unclear how the sham subpoena could be court-ordered, given that no judge was assigned to the sham action, which would have required the filing of a request for judicial intervention. From the standpoint of someone in the general public, it's pretty disturbing, and the kind of thing that, if allowed to happen commonly, could be used to bypass someone's reasonable expectation of privacy to publicly humiliate and destroy them without them ever knowing it's coming, and in the most dire of circumstances, might just end up being someone's 13th fucking reason. Some people might say that's dramatic, but really think about it. If the most important project of your life is blowing up in your face, someone much more powerful than you is working behind the scenes to ostracize you. You're so stressed out to the point you've been in the hospital, and now someone has somehow gotten a hold of some private communications of yours that can be used to make you look like some sort of weird and evil internet bot overlord, not to mention selectively disclosed and devoid of context in a way that makes you look like the bad guy and makes other people think that you're some sort of sexual predator. The subpoena to Edgeworth seeks documents concerning JonesWorks' receipt, use, and disclosure to Lively of Miss Abel's communications, the facts of which are undisputed. The misconduct by JonesWorks constitutes tortious conduct and a violation of multiple federal and state statutes. The sham action and the sham subpoena, which were unquestionably designed to provide a false cover for JonesWorks' disclosure of Miss Abel's communications to Lively without notice to Miss Abel or any of the Wayfarer parties, constitutes serious litigation malfeasance. The court should find that the crime fraud exception applies to JonesWorks' claim of privilege. As the Wayfarer parties prepare to seek further relief without respect to the sham action and sham subpoena, we respectfully request that the court deny JonesWorks' motion and compel Edgeworth to comply with the subpoena, or, in the alternative, conduct an in-camera inspection of the disputed documents. In-camera, not to be confused with on-camera. That's not what we're talking about here. That means the judge would review it in private. And the attachments to this letter are just the documents relating to the Vanzan lawsuit. There were a couple of other documents filed last night, one of them a motion to compel answers from the Wayfarer parties, filed by Blake Lively. We went over those a little bit last night, but I said I was going to do a recap of some of the more important things. Unfortunately, that is going to have to wait till a little bit later because I do have to sleep sometimes. That's all I got for right now. Thanks for watching. I'll see you all soon.